the coin, to increase value, they go on a worldwide media tour. It's an important fact to this, am I right? The media tour is an important fact to this whole process. Okay, so they have this campaign. It's called Don't Let Them Flake, Make Them Beg, Borrow, or Steal to Buy Tokens. Very successful campaign, kind of a catchy title. Lots of tokens bought, value skyrockets. They're able to make this acquisition. Unfortunately, though, Kimmy, who's well known for driving G-Wagons and Range Rovers, is found in front of a Fiat. And inquiring paparazzi say, what's the story with this Fiat? She says, look, I don't know anything about finance, but they tell me that this is the backing for the coin. Don't you know anything about it? Fiats are what's all important about it. It's a fiat currency. So supposedly the fiats are really the backstop of the coin. Well, as you might imagine, when the folks in the city hear that that's the backstop for the coin and not some algorithm that really would have given it some sort of intrinsic value, it's all over the media. You see some of the screenshots about the fiat currency and the avalanche of fraud. There's a general counsel because, of course, there's a lawyer in the midst of this. Unfortunately, I think perhaps the general counsel might have been the friend of someone. The hypo doesn't go into the whole detail. Seems like the qualifications might have been a little light for the application process. But he had spoken to Paul Miege about the snowflake coin, confirmed that snowflakes in fact are unique, so that he thought their claims about their coins being unique was sufficiently backstopped because they had the expert report. Apparently there were other issues and other experts he might have wanted to consult, but I'm sure the panel might go into that. There are this whirlwind media tour, which also involves bank accounts. There's Slack communications. There's a whole host of evidence to be found, culled, destroyed, whatever the bad actors might have thought. Deletees, because he's seen this play out before for friends of his who also were ultra successful. He decides it's time to leave. He goes to an abandoned headquarters that had been the headquarters of the Great Embers Festival in Exuma, which was a spin-off of the Fire Festival, but it's still available. And so he and his colleagues are there trying to sort of plan their next steps. There's an arrest. There's some time at Her Majesty's prison, or His Majesty's prison, Foxhall in the Bahamas, which I've had the misfortune of visiting, and is a horrific place on the Amnesty's list. I was only there for a short period of time, seeing someone left shortly thereafter. But that's the facts that you're all presented with. I'm sorry. It's a crazy story. But tell us, if we get the call from one of these people, what are we supposed to do? Turn it over to you. Give us the answers.
Well, I will say, and we will say, that we did not craft this hypothetical, and as you can see Bill explaining it to you, you can all know that it is coming from his imagination. So bravo and merci Bill for this. I'm not sure how dragons have now been replaced by cyber geeks and princesses by influencers, but it seems like you've got something going. But let's begin and let's make this real. Of course, it all starts with a phone call. And I've decided that the phone call is made to myself. Victoire, I'm representing Bonifassi Avocats in Paris and acting as a litigator in white-collar criminal cases and asset recovery. But on the other side of the line, there's a huge case, and I'm sure you all want to be part of it. For the moment, I have decided to make phone calls to 4 of my eminent colleagues. But if you want to join in and hop in the conversation, please do so. I think we will all be happy to have your expertise, especially if you have just read the hypo and it's like all fresh in your mind right now. Definitely want that spontaneous comments. So the first call, and I did do a little
Outstanding.
but the first call I'll be making is to Nick. Nick is the head of business crime and investigation at Peters & Peters. And before joining Peters & Peters, he was head of special crime at the Crown Prosecution Service, overseeing most complex case work. He also held the 3 most senior international prosecution posts: head of extradition, head of the UK Central Authority, and the UK legal attaché in DC between 2007 and 2010, working with the DOJ and US-UK cooperation. Nick has now changed. He now represents individual and corporate clients on a full range of international and financial crime, including extradition, mutual legal assistance, fraud, money laundering, and export control. Since January 2020, Nick has represented the Post Office in the largest of series of criminal appeals in the UK legal history. And since August 2022, he has represented Boris Johnson in the UK COVID inquiry and at the Privilege Committee inquiry into whether the former Prime Minister misled the Parliament over the Partygate. So it seemed very appropriate to give Nick's phone number to the GC of the Flaking Exchange. But I also thought that Nick would probably want to work with Zoe on this investigation, as Zoe is the regional managing director of Global Head of Financial Investigation Practice based in London at Kroll. Zoe has more than 20 years of experience working across Eastern Europe, the CIS, and the Middle East, and has led numerous international cross-border investigations. These investigations require the tracing of complex funds flows, dissections of corporate structure, which will be very useful today, assessment of integrity of transactions to support both civil and criminal asset recovery proceedings, and disclosure to regulators. And then I decided to give Joe's phone number to all of the board members included in this hypothetical, because they're going in every direction, and I thought he would be the best one to figure out how to advise them and figure out their risk and liabilities. So Joe represents clients nationally and internationally in a variety of white-collar matters. He is based in Atlanta. In addition to his years of private practice, Joe has served in several high-level roles with the DOJ and the DHS. During the Reagan and the Bush administration, he served as Acting Associate Attorney General, the 3rd ranking position at Main Justice. He was also appointed by President Reagan and President Bush, respectively, to serve at the U.S. Attorney in the Middle and Northern District of Georgia. He has served under 5 U.S. attorneys and 4 presidents in a number of key and operational positions. In 2003, he was appointed by President Bush as the first General Counsel for the Homeland Security. And Joe's now practice focuses on corporate defense and representation of clients in complex civil and criminal enforcement matters. Finally, with extensive experience on whistleblowers and False Claims Act investigation, it seemed very logical to give Margaret's phone number to the former accountant and the former exec accountant, and refer to the hypothetical to figure out who they are. Margaret is a senior associate at King & Spalding's Special Matters Group in the London office. She began her career in DC, and she is both US and UK qualified with a global practice. She focuses on cross-border criminal and regulatory investigations involving financial crime issues such as bribery, corruption, money laundering, market manipulation, and sanctions violation. She regularly advises clients on financial crime compliance, both to help them develop and supplement their own compliance programs, or provide a risk assessment regarding a target company for potential merger or acquisition, and recommend post-closing compliance enhancements, which probably would have been useful in this hypothetical in a previous stage. Margaret also has experience representing whistleblowers in the False Claims Act investigations. So I didn't manage to get out of this case quickly enough, and I'm going to be the liaison between all of them. But, Nick, you are getting the first phone call from the GC, who's now located in Great Exuma with JDL, so delatiste, but I will make it faster for this panel. And he's trying to figure out what to do, but let's be honest, his position isn't very clear.
No, thank you, Victoire. I mean, there is a lot going on in this hypo, and I don't think we're going to cover it all. So I'm going to try and just focus on a few key topics, none of which I think will be a huge surprise to anybody who's read it. So initially we just got to figure out who needs representation. There's different entities here, individuals and companies. In respect of what conduct do they need representation, and in respect of which jurisdictions, and then we're going to need to work through who exactly can give us instructions, how are we going to get paid. I'm not going to delve into that, but obviously subject nearest to most of our hearts. So that is something that you would think about, but maybe we don't need to cover it in any detail on the panel. I mean, what do we know? When I speak to the GC, I try and figure out what I know already. So he's the GC for both of the entities, which is SSV and the Flaking Exchange. And he's been in that role throughout the entire period, which now appears to be a massive fraud. So there's a huge rise in the value of the coin based on a influence campaign which he signed off on, which now appears to be completely false. And the valuation that that campaign created was used to buy SSV assets out of bankruptcy. And then there's been a massive crash when this apparent fraud has been revealed. You've got lenders calling in notes. You've got law enforcement seizing assets, presumably launching criminal regulatory investigations. 2 board members resigned, we've got 3 remaining. And the GC, he wants to respond to it all, and he started to gather records. But of course, what is his personal position? As Bill said, he commissioned the so-called expert, which he claimed to be the due diligence he conducted on the value of the coin. He reviewed, negotiated, authorized, signed off on the whole marketing campaign, which turned out to be completely false. Presumably he was involved in the representations to the banks when SSV was purchased out of bankruptcy. And also he seems to be part of the inner circle, because if you read the hypo, when the story first breaks about the fiats, a whole load of people get a tip-off and offload their coin, and he's one of those people. So we can infer that he's in some kind of inner circle, whereas 3 of the board members apparently are not. So that sort of places him really at the heart of this. So assuming there is some UK jurisdiction here, by the way, which is why Victoire has called me. So let's assume, for the sake of this hypo, that some of he's British, some of the conduct which constitutes the fraud, alleged fraud, has taken place in the UK. There'll be UK victims, of course, as well as victims all over the world. If, and this will be discussed, I know, further later, if all the different law enforcement agencies were coordinating, I wouldn't expect our Serious Fraud Office to go after any of these companies. They would probably focus on somebody who had more direct UK connections over whom they have jurisdiction. So let's assume the SFO are looking at him. They're also thinking about looking at the company, but they're coordinating with their counterparts in other countries. So he's involved in all the key conduct on investigation. Conflict is inevitable. He can't run this investigation. I mean, it's actually a question for the companies whether they want to run an investigation at all, or whether just sort of hunker down and let things take their course. But again, I think for the sake of the hypo, we need to assume there's an investigation coming. So we could try and ride both horses for a while, say, well, we can represent you, SSV, and the exchange. But as I said, I think conflict's inevitable. So we need to start thinking through that straight away. And I think for the purpose of this hypo, the GC wants to instruct me personally. That's the way we're playing it.
All right, but then what about the notion of like privilege? Because that's going to be something that you're going to need to take into account whilst, discussing the initial calls with him.
Yeah, and so obviously we've got to look at privilege going forward if there is going to be an internal investigation with the usual principles that I think Zoe's going to touch on. But actually the interesting question here is the privilege over the advice that he's given to the different companies of which he's the GC, which appears to be completely false, and either he was an unwitting conduit for this fraud, or he was knowingly involved. So normally, of course, the privilege is going to belong to the companies to whom he gave the advice. But what's going to be interesting here is the extent to which the crime fraud exception applies. And I assume think the rules are pretty similar in the US as in the UK. So even if the GC wasn't aware that the advice he was giving was for the purpose of committing a fraud, then that advice is not going to be privileged. So maybe the company themselves sought advice from him knowing that it was just a cloak for a fraud that they were going to conduct. Maybe JDL in his personal capacity, effectively as a third party in this client-solicitor relationship between the GC and the companies, is actually the ultimate fraudster, and he's using these companies and the GC without their knowledge. So whichever, the knowledge of each of the parties in this relationship isn't relevant to whether the crime fraud exception applies. And I think the law enforcement's theory is going to be that this whole thing was a fraud from the start, and therefore any advice that the GC gave is not going to be privileged. So we need to think about two things from his perspective personally. He may want to be saying in his own defense, because that's what I'm going to be talking to him about almost from the outset. You can disclose to law enforcement and use, if you're interviewed, the advice that you gave, the instructions that you received, without breaching privilege, because you will be asserting that you are the innocent victim of a fraud, and therefore that advice was not privileged. Serious fraud office, as my UK colleagues will know, could serve a Section 2 notice, a compulsory disclosure notice against him personally or any of the companies, and they say, we would like all of that privileged, so-called privileged advice, because we're asserting that the crime fraud exemption applies, and therefore all of it is up for grabs. So we'll need to think that through, because there's liability, of course, in the US, Spain, France. So I've been wanting to speak to my colleagues in all of these jurisdictions, because he's going to need representation in all of them, to say, well, if this is the tack we're going to take in the UK, that we're going to say the advice wasn't privileged and we want to refer to it in own defence, how's that going to play out in your jurisdiction? Because, of course, you already need to be thinking ahead to some kind of global settlement or a global defence if actually you think you've got a good line of defence and you're just going to hunker down and take your chances.
And so he's, for the moment, he's not in Spain, he's not in France, he's with his partner in crime, I would say, in Great Exuma. Is there a risk of extradition for him?
Yeah, I mean, in these kind of cases, one of the first questions you often get asked is, will I be extradited to the US? Because that's the place I don't want to go. Because, you know, the penalty will be higher, my chances of defending myself at trial will be much more limited. So, I know US lawyers have to be very careful. I've worked on many cases where this has happened. They can't give advice that appears to be assisting somebody to evade law enforcement. In the UK, we can't give direct advice of that nature, but we're less inhibited about advising on how well one can resist extradition from one jurisdiction compared to another, and the ways in which you might get advice at time in the extradition proceedings by delaying them, which is going to be crucial for somebody to get their affairs in order, or to line up their defence, or to negotiate with other jurisdictions. So I imagine the GC would be asking me from the start, well, where should I be in order to avoid extradition to the US, or where's the best place to buy myself some time when I can just make sure I completely understand my risks, speak to my lawyers from all these different jurisdictions, and then maybe speak to the US or these other parties in a place where they know it might take a little while to get me from. And actually the UK is a good place to do that from, but as I said, we just need to be careful that we don't cross the line, especially working with US colleagues, where it looks like you're giving advice about how to evade law enforcement.
If we listened to yesterday's panel on extradition, it seemed like Denmark or Spain might be a good place also to avoid extradition.
There's lots of good. I don't know about Great Exuma, but I imagine they would hand people over pretty quickly.
So now that we've cleared out the situation at least a little bit, and know that you will be representing the GC personally, you were inclined still to make a phone call immediately to Zoe, who's going to be conducting the investigation for the companies, because they do need that help. And I will let Zoe explain how she would go around. And firstly, I think one of the most important points that Nick touched upon is who is going to be Zoe's point of contact, and who is going to be the person she's going to put in place that investigation.
Thanks, Victoire. Thank you, Nick, for the referral. So, talking to a room full of lawyers, I'm not going to go into privilege here and be in great danger of being out discussed quite quickly. But it's a problem we face frequently. We often get the first call when a client's found an issue and they want to engage us immediately and start work immediately. Obviously we're very cognizant, particularly in the Hypo here, where the government's involved and the government's also appointed receivers, that any work that we do needs to be under the cloak of privilege. One of the big issues in the structure of the Hypo is who on earth is going to be our client. You've got SSV, you've got Flaking Exchange, you've got you've got a founder who's under great amount of suspicion, and you've got a GC that's not covered himself in glory. I would be hoping that there would be some sort of top coat above the two entities that could instruct us, and that would give us access to both entities' records, because again, one of the issues that we would face is if we're appointed by SSV, can we access the records of Flaking Exchange? If we're appointed by Flaking Exchange, can we access the records of SSV? So all of that I would call on my wise US counsel, and hopefully we will be instructed by external counsel on behalf of the firm. I think one issue as well is who actually within the company is giving us both our instructions. The GC is conflicted, and we have got a board of directors whereby a number of the board of directors, we probably wouldn't know at the time of getting the call, but would know further down the line, are conflicted because they've all dumped a load of stock and cashed in the moment the crypto coin collapsed. So again, what we would be looking for is some kind of independent special committee of the board to be instructing us. But the key really is to try and make sure that we are able to access and harvest as much data as possible in those early days to be able to do a properly comprehensive investigation.
But we've got the people who would be making at least the first phone call are located in Greater Sula. We don't really know where anyone else is based. We don't really know where any of the data is based. So how would you go around, identifying where you want to start, pretty much?
So depending on how we're instructed, I would be asking Nick if we could have a pretty quick fact-finding interview with the GC. Usually we can be as effective as possible once we've found that trusted person within the inner circle who can navigate us around the systems, the data systems and the financial systems available within the companies. Obviously, it sounds like a bit of a nightmare because you've got resorts all around the US, you've got the exchange itself, and you've got money being transferred all over the place. However, typically there will be a central HQ, certainly for SSB, and certainly for the exchange, where we will be looking to get on the ground quite quickly and start at least securing everything. We might not be looking at all of the data, but at least securing the data. I would also say sort of at the moment we've got one investigation whereby again we have to be retained very quickly and we have to secure the data very quickly because the US authorities were involved, receivers have been appointed over as foreign subsidiary, and the investors in this company wanted us to figure out what was happening quickly. Nowadays, more than ever, as you probably know, it's getting less and less necessary to go on site and conduct huge imaging exercises of hundreds of laptops and telephones. We were able to pretty much download a load of information from Southern Europe, almost the entire company's Google Mail and Slack and Google Workspace data over a weekend, and host that in Paris and start reviewing it the following week.
All right, but then if we have to collect information from other parties who may have been involved in the scheme, how would you go around with getting that information? How would you go around with trying to obtain the right authorization to obtain these information?
Well, there's lots of interested parties in this hypo, and one of the first things we will be doing pretty quickly is looking at the connections with the board members who I think come from the greater good of the marketing and social influencing world as opposed to the corporate governance world within SSB itself. We'll be looking at the cast of characters internally and externally to understand conflicts of interest and where there may be relevant associations in terms of answering the key question, which is who, what, when, in terms of the fact that this ultimately was a big fraud. But what we will be starting to do is really look at the likes of GFH, the marketing company, and also if whether we did or didn't have access to the flaking exchange, we will be working with council that we were instructed by to get them the relevant information to show association to try and go and get the correct disclosure orders and send to get the information available from them. One of the main objective of a lot of the work that we do where there's a fraud is recovering money. And it's clear in this situation that there's a lot of asset dissipation that's already happened. So we would also be looking at sort of the private jet paths, where has that flown to? I think there was something in the details, which I have read of the Hypo, around how they were setting up structures once they'd diluted a lot of the crypto coins. So we'd also be looking at trying to, in the background, understand the structures that were associated with different individuals involved.
In terms of assets, the fact that you would have the government trying to locate the assets, the receiver trying to locate the assets, and also, well, you know, millions of victims in the case, how would that impact your investigation?
It all depends, and this is where we 100% want to be lockstep with the council that we're instructed by. Typically, there's a bit of a race, and I kind of assumed in this hypo that we were probably ultimately instructed by the banks within who had secured the lending into SSV. So it's sort of a race to see what you can identify first. So that's one of the first things we can almost immediately start before we've got the data processed and analysed. What we can find out externally about individuals and entities and their footprints to generate leads that will then inform how we interrogate financial information and get more leads once we have access to the Slack and the email and the financial records as well.
I think from an asset recovery perspective, there's also the question of it is crypto, and crypto has this not meaning, but at least for some individuals, it can be, well, it is linked to fraud and it's going to be difficult. But really, crypto is something that can be traced until it reaches the exchange points, and then you need to get in touch with the exchange. So here, how would you manage that?
Well, in my experience, in where crypto is involved, you've got crypto experts and you've got crypto definitely not experts, and very few that sit in the middle. And crypto tends to make people panic once it's related to a case, because it's not something many of us are hugely comfortable with. But practically, it's just another data set of transactions that sit on a ledger. So my answer to that is I'm no crypto expert, but we trace crypto all the time. It's just a slightly different tracing methodology. And once you hit an exchange, you've got to get disclosure orders to understand where it's gone on from there. So what I would say is, don't panic if you're not a crypto expert, just think of it as another data source. It can be traced, but it gets a bit more complicated once it hits exchanges and splits off, and that's where you do need to get the relevant data sources, disclosure orders and things.
All right. So we've got Nick and Zoe working on this investigation. Well, Nick is kind of trying to understand what the GC's position is.
I don't accept Zoe's invitation to talk through where all the data is. I'm just going to keep quiet for a moment.
But not everyone is following JDL, or some at least are, hesitating and they don't really know where they stand. Joe, I believe you received a phone call from different board members, those who can still believe that the boat can float and those who have clearly just jumped off the ship. What's your take? Will you be helping some of these board members out? What are their risks? What are their liabilities in this case?
Well, certainly, so I want to comment on footnote 1 in Hypothetical, which is the facts in the hypothetical have no connection to any real life event, but they do, of course. And so the combination of John Grisham and Dante putting this hypothetical together, because it is a bit of degrees of hell for different individuals. So I think as to the three board members who are wanting to stay, for purposes of the hypothetical, let's say that they are somewhat more innocent in the process, and I would think that's something that gives me a bit of an anchor to tie into and create something in the nature of an audit committee or special committee to advise me, or that I could work with as I go through the process of trying to salvage the company. And what's happening right now at FTX in New York, there's a criminal trial going on, but there's a parallel bankruptcy happening with FTX, and an individual by the name of John Ray is the chief executive of FTX, and he successfully kept away from the process, the appointment of a trustee or examiner in bankruptcy. So he's, let's assume that John Ray survives all of this and that he's advising me, someone on the board. I do think getting the board members' counsel, and there would be conflicts, obviously, and I think we talked about this earlier, conflicts between the various parties, but let's assume for purposes of the discussion there's a common interest between them. I do think I would be looking immediately for money to pay me. We talked about this, the D&O insurance for the board members is important. There is the advice of counsel defense that I'll throw out, that your client is in great example, but he's advised the board as to certain things. As to the other two board members, Victoire, I might also have some contact with them and suggest that they obtain counsel. I would want to find friendly counsel. There's a difference, right? If they were to go out and find counsel that's not friendly, we wouldn't be able to have dialogue with them. So that's another thing to think about. In terms of the SFO and Department of Justice, there would be other agencies looking at this scenario that I need to be thinking about, and that would be the CFTC. Is this a commodity? Is this Bitcoin or this type of currency a commodity, or is it a security? And so the SEC would be involved potentially in looking at this issue. As I think about the board members, going back to the Assistant Attorney General presentation, criminal division, I'm thinking immediately about voluntary disclosure and trying to get messages back into the different law enforcement agencies that my clients in the special committee are wanting to be allied with the Department of Justice. We were very concerned. We didn't know this was all happening. We could pull that off. But we didn't know that JDL was a criminal and was doing all this shenanigans to create the appearance of value in the Bitcoin, and the Bitcoin is worth exactly the value of a real snowflake, as opposed to a snowflake being backed by real value. So sort of in that perspective, the voluntary disclosure piece for me, if I were to get permission as a special committee, is I would want to find a way to work, if I could, with Zoe, who's someone I think would be very important to production of information. I think that alliance, and I keep coming back to that, I think it's important to save and protect the assets of the investors in this debacle. There is obviously some discussion that we want to have with each of these law enforcement agencies. There are 94 U.S. attorneys' offices that might have some interest in this. I think where this usually ends up is in the Southern District of New York, and that's probably where the prosecution would be coming from. I could touch on more issues, but I think some of what we discussed, obviously, don't want to be in a place where we're at the back of the queue. Don't want to be extradited, obviously. I'm not sure where the board members are located. Let's assume they're all here in the UK. I think that's a good place for them to be. Great Exuma seems a little bit like the Bahamas, and it's a place that has a friendly relationship with the United States. In fact, years ago, I helped negotiate the extradition treaty with the Bahamas on behalf of the Department of Justice, and I feel like I contributed to Sam Bankman-Fried's early return to the United States. But there's just a lot here that makes me think I'd like to mirror, although it's probably unique, you need to have someone who is a good actor inside of this organization that's been essentially a bad actor. I would think maybe there's a bit of a PR campaign that's important to think about, because you've got the influencers who've been out there, let's say, in Sam Bankman-Fried situation, basketball players like Shaquille O'Neal, other famous actors and celebrities were part of the influencers. So not only do you have incoming from the Department of Justice, the SFO, CFTC, SEC, all the acronyms, but also you may have a class action happening. I think that's important to think about, and how to deal with that. So there is some utility to having the receiver in place or someone in place to sort of help deflect that. And you do meet the standards for a class action here, because you do have you have much more than $5 million of losses. So those are a few things that are coming to mind before thinking about, hopefully I hit on some of the things that I needed to touch.
Of course. You mentioned the 94 AUSAs. I think in this category you would also get the issue of having people and victims all around the world. The ski resorts that were mentioned, and I'll stick to those, but were in Spain and in France, so you would also have these cross-border issues in the way you deal with how the board members want to go around their own personal responsibility. With regard just to the class action, I'm not aware of what the jurisdiction is like in the UK, but at least for France, this would be something that's not possible. So the class action would be in the US from our point of view.
I would say, sort of touching on defenses, it would be obviously for all the board members, I might be arguing that advice of counsel is very important, that they relied on that, so I would not be worried so much about the crime fraud exception. Making sure that actual advice got out there would be important as part of the defense in the criminal matters, but also in the class action.
Thank you, Joe. Margaret, I think you've been called by two important individuals in this whole mess. One being the account expert, which made a phone call to a EU regulator, and the other one will be the former exec who's trying to make his way in this case and find a breach. So how would you answer those phone calls?
Yeah, so I guess just to start, I would say that in the real world, I'd probably be thinking about whether there's a potential conflict representing both of those whistleblowers, or even just sort of optically whether that looks good for credibility. But for purposes of this panel discussion, we'll say I'm representing both. So I don't think Bill really touched on it in his overview, but one of these whistleblowers is the former accountant for JDL. And the hypo says that it appears like he's been working with EU regulators for some time about spending patterns and money movements, and that information had been shared with U.S. authorities in Denver, but had not been a focus of interest until now. So I read that to mean that the former accountant is JDL's personal accountant, as opposed to an accountant for one of the companies. And I think, first of all, I'd want to establish, what does this accountant know? What kind of information has he or she been leaking to the authorities? How does that factor into the case? I think it's very possible that the accountant has information about JDL's unloading of the Snowflake coin just before the value plummeted, and the investment of the money in stablecoin, and the series of entities that were established during the around the world tour of TV studios. And all of these facts, I think, tend to suggest a premeditated, coordinated scheme to drive the value of the snowflake coin and then unload it before its value tanked. So I can see why the potential information the accountant had would be of interest. The accountant might also have information about JDL's assets, which would be relevant to potential claims arising out of how he represented his buying power in the acquisition of SSB, and maybe some information as well about the fiat collection that is backing the snowflake coin. So I would start by establishing, what is the information the accountant has, what have they been saying to the EU regulators, and then I want to talk to them about their potential responsibilities, their potential exposure. As an accountant, I want to confirm whether they have any professional secrecy or confidentiality obligations that they might be in breach of by disclosing these obligations, or by disclosing this information to the authorities. I'm not an accountant, but I don't know exactly what their confidentiality obligations would be, although I assume they must have some. On the flip side, I think in a lot of jurisdictions, accountants have responsibilities to report potential criminal misconduct. So I would want to look into whether the accountant was fulfilling some kind of professional obligation by bringing this information to the authorities, which would then get them out of any potential issues from disclosing confidential information. And I'd also want to look at whether the accountant is exposed to potential civil claims from JDL. Was there an NDA in place that the accountant has breached that's set them up for a lawsuit from JDL? And I think last of all, I'd probably also want to look at whether there were any data privacy issues with sharing this information. Accountants collect what would be considered personal data under the GDPR. However, I believe there is an exception for sharing information with the authority. There's a personal or professional obligation to report. So those are just some of the initial considerations that I have when talking to the accountant.
And so when he decides to talk to the EU regulators, he's already done it when he gives you the phone call. But do you think that he had in mind any questions related to immunities with regard to his personal responsibility and the fact that he's cooperating, and how would you advise on that point?
Yeah, I think that's very possible. In recent years, enforcement authorities like the DOJ have said that they're going to look more at holding what they call gatekeepers responsible, and accountants are within that category of gatekeepers who can potentially allow misconduct to occur or prevent it from occurring. So I think depending on the accountant's involvement with potentially problematic money movements, he may be feeling that he has some potential criminal exposure and is looking to cooperate up front to hopefully get cooperation credit or immunity to avoid being charged himself by doing the right thing. So that's definitely something that I would explore with him.
And the hypothetical states that the EU regulators has sent the information to Denver, but that it seems the US has done nothing about it, which in real life probably would not happen. But now that the EU regulator is on the matter, the US has the information. How would you advise the accountant on to his US, to the relationship that he could have with the US authorities? And what they would expect from him?
Yeah, I expect that the U.S. authorities are going to want to talk to him, so I would recommend that he have counsel that can represent him in those dealings with the U.S. authorities. And I think that, again, we would be looking at whether he has potential exposure in the States for anything that he's done, and whether he needs to be concerned about that, whether there's any amendment issues or how he wants to play it to hopefully cooperate and not expose himself to criminal liability himself. So I would be recommending that he get counsel in the U.S. and anywhere else also that he ends up being interviewed. There's, as we've said, a number of jurisdictions in play here, and we've talked quite a bit over the last 2 days about how authorities are collaborating more around the world, so I think we can expect that there would be a number of different jurisdictions that would be interested in talking to him.
So now we're going to flip to your U.S. cap lawyer and deal with how the former executive from the VFH, has given you the other phone call, and he's working on thinking about a class action, though that's been touched upon by Joe, or key town cases, but you know, he could actually be considered as a whistleblower himself, since he was inside the company. How would that, how would you handle that?
Yeah, so the BFH account exec, I think, would have worked on the influencer campaign. I think that was BFH's contribution to this whole debacle, was setting up this influencer campaign. So I think it's very possible that, and I would want to learn up front what he has to say exactly, but I think most likely it would be information about what went into planning that influencer campaign, what was the intent of everyone behind it, what did they know, did they know they were misrepresenting the reality and issues like that, which would certainly be of interest to regulators. Whether a key TAM case is really the right thing is a different question. So for any non-US lawyers in the room, key TAM claims are claims brought by relators or whistleblowers on behalf of the US government under the US False Claims Act. And the government can choose whether to intervene in the case and prosecute it themselves, but if they choose not to intervene, the whistleblower can still move forward with the case on their own. And in either scenario, if the claim is successful, the whistleblower gets a percentage of the recovery, and how much they get depends on a variety of factors, like the importance of the information that they contributed, whether they were part of the wrongdoing that then led to the claim, and various other factors. But the False Claims Act itself prohibits knowingly submitting or causing to be submitted false claims for payment to the U.S. government. And that can include submitting a false record or statement that's material to a false claim, or using a false record to avoid or decrease an obligation to pay. And in this case, I'm not quite sure what would really be the false claim submitted to the government. I'm actually curious if anyone in the room has spotted a basis for a key TAM claim that I have missed. So I will open it up for a little bit of audience participation on that front if anyone has thoughts.
Bill, we're all looking at you now.
Well, I will assume you all agree with me in that case, and I think perhaps a different whistleblower program would be more appropriate in this case. We have the SEC reward program and the CFTC reward program. I think it was Joe that touched on the fact that certain cryptocurrencies are considered securities and others can be considered commodities. So we would want to undertake an analysis of which regulator is the more appropriate one to go to. But there are whistleblower programs at both of those agencies where you can report violations such as insider trading, market manipulation, and pump and dump schemes, which I think arguably all occurred here. And under those whistleblower programs, it's very similar to False Claims Act cases. The whistleblower has to be what's called the original source of the information. So if the government already has the information that the whistleblower is bringing forward, then they're not the original source. They're not providing much added value. So I would want to establish, what information can the account exec provide that is, adding to or different from what's already out there in the public domain. Obviously, there's been a ton of reporting on the influencer campaign. There's a lot of information flying around, so we'd want to pin down what they're bringing to the table. And I also want to do some diligence to test the credibility of the whistleblower's information, because under these whistleblower programs, credibility is important. The information you're bringing forward has to be truthful. in order to recover under the reward programs, but all of that would have to be balanced against timing. So under the whistleblower programs, you need to bring forward your report in a timely fashion. You can't delay forever, otherwise it's not really helping. So we want to do enough diligence to make sure that, okay, this whistleblower has a credible claim, we want to bring this forward, but not take so long that some other whistleblower comes forward first, the information is no longer useful or timely, and we go from there.
All right. So I think from a UK-US perspective, we've tried to cover as much as possible that we could, but I'd be happy to hear, especially on how would you react to the GC giving you the first phone call, or to the accountant who has been leaking information to the EU regulators, from people from the audience, and maybe I will call upon the Netherlands or Germany to know how they would, how they would react, or people from Switzerland or Italy, anyone.
So I'm not from Germany or Netherlands or anything, but I do have a question. Margaret, you mentioned the GDPR.
Yeah.
And I'm curious, Zoe was talking about this a little bit. What impact is that going to have on your data collection, and particularly with transfer of data to the U.S. at some point, for instance, if there is a false claims?
Yeah, GDPR is obviously a huge issue that comes up in cross-border investigations, and there's different bases for exemptions from GDPR requirements that can apply in an investigations context. I will not try to pass myself off as like a huge GDPR expert, but we usually work with our GDPR team in the firm when we're dealing with this, and we look at whether the data is being used for purposes of investigating or defending a potential criminal issue, and that can usually be used as a basis to transfer data. And turn it over to Zoe.
Yeah.
If you have more to say.
And I think the helpful thing here is most of the data seems to be in the US, but I think it also said that there was Spain and France, and that's why in the first instance we will typically secure and then hold it in jurisdiction while the lawyers work out the GDPR issues, where it can be hosted, whether the US council can access it from the US or not. Usually it's decided that it can, as long as it's hosted in Europe, as long as it's not in Germany.
Yeah, from a French perspective, you'll have the GDPR, and obviously the question of, am I using this information to cooperate? Am I using this information to disclose a wrongdoing that was committed by the company in terms of defense? Then this will be part of the exemptions that you can use for at least revealing the information to your local authorities. Transferring is another matter. But you'll also have to take into account in France, and I'm sure our reputation is far beyond what I can expect, but labor laws in France will have a huge impact on internal investigations in terms of delays and in terms of who you are meant to inform of the internal investigation. And it is, if you happen to have any internal investigations conducted in France, something that really needs to be taken into account, and have more than a GDPR specialist, a labor law and employment law specialist in France. This is crucial to the to make sure that you are conducting the investigation and respecting all of the employees' rights in there. Any specialty in any of the country represented in the audience that would be worth mentioning in terms of, well, GDPR is European, but in terms of something that might be special to your country?
From the class perspective, in terms of the duty to preserve, yes, the data is probably, to Zoe's point, centrally located in this but what about the other executives, board members who have data they talk about it personally? Who's communicating to that duty to preserve evidence, and how do you manage that?
And very good point, particularly as it's not a particularly high corporate governance organisation, and what we find increasingly now is obviously a lot of the interesting stuff is on WhatsApp or similar messaging services, and increasingly in these sort of high growth entrepreneurial organisations, they've got their own mobile phones and you can't get it. And obviously usually the most interesting people are the people not willing to hand over their phones voluntarily. So it's what we find in a lot of leak of information cases and similar is the board and C-suite saying, look, we're offering up our own Gmail accounts and our own phones. We'd like everyone else to do the same, but you're sort of at the mercy of whether or not people are willing to do or actually offer up the correct phone or email.
Yeah, and often you find people will use one phone for multiple purposes, so they'll have all of their business correspondence on there, plus all of their personal stuff. Some of it may be extremely personally sensitive, they don't want anybody to see it quite rightly, so it's often a challenge.
Yeah, very much so.
Sort that out from a GDPR and a technical perspective.
And particularly investigations in the Middle East, we have to be very sensitive because there's certain information that people may have on their phones that could have real repercussions for them that's private to their private life. So we have to be very cognizant of that.
So in the room, people, not taking a poll, but many of you have two phones, and so that's another issue. As you think about the documents preservation, I think your point's a good one, which is absolute no credibility with the federal government or law enforcement if you haven't done something to preserve the documents and information. If you're having a conversation, you say, I have no idea what the board members knew and when. It's just not going to sell. I think it's a really, obviously, very fundamental but critical issue to bring up. But I think that the WhatsApp aspect, all the other technology to hide and obscure information, when the federal government knows that you have some of those applications on your phone, it's just a red flag to them that there's a problem. I mean, that even though it's typical and ordinary for you to communicate with family members with those types of things, it's just not, it's still, I think there's a prejudice that the Department of Justice has against those, and it puts you in a bit of a box.
I think just one of the points about it, it's probably no surprise to anyone here, but whereas people are much more careful on email nowadays than they ever used to be, the massive uptick in the use of Slack and Teams chats, people are a lot freer in that, and I think now it's the ability to properly mine that data and see who's talking to whom. You sort of get the feel of the person through that data much more so than the email.
I think in this hypo, just to be honest to it, if I was advising the GC from the start, you'd probably be saying, put a document hold in place, do the right thing by the company, and then remove yourself. Because what you don't want to be accused of is covering up or from sort of fault through omission. So you need to do those basic steps and then remove yourself because of conflict of interest.
I think one thing that we probably kind of avoided, Bill, let's be honest, given the amount of topics that there was, is the fact that there is going to be a receiver, and Zoe, you touched upon it a little bit, but there is going to be a receiver appointed, and he's going to be trying to identify the victims and the assets. Would that have any impact in terms of how you would be handling the matter more generally, and let's get out of your personal roles in this matter? But
I mean, for us, it all depends who we were working for, and this is a government-appointed receiver, and they would have enormous powers. But what we often find is they are over one entity, and it's whether they can get to the other entities in the group. And if we're sat at HQ, you're trying to sort of, as I say, almost race to the assets on behalf of your stakeholder first, before the receiver gets in. But equally, in these sorts of investigations where the whole point is for us to be independent, working with counsel and be proven to be independent in what we're doing, I think the key is eventually to have a good dialogue with the other stakeholders. So our information can be shared with the government, can be shared with other receivers as necessary, but it all depends how it's panned out. I think one area that we probably haven't touched on just due to time is also being cognizant of potential claims against other third parties. So we talked about the valuations that were given to the banks at the point of the acquisition of SSV. You know, how deep were they? Could they have known? Should they have known in terms of third party claims? Similarly, auditors, are the claims against the auditors of the flaking exchange? Did they look at what was ultimately behind it or not? So I think that's just another parallel angle to bear in mind during the investigation.
Just a moment of reflection on FTX, which is not the basis for this hypothetical, but is the appointment by the bank. There's a bankruptcy proceeding in FTX in the U.S. and the significant powers given a person who was appointed as an examiner to do a lot of asset tracing. For example, before many people's time in the room, Enron, there were a lot of things that sort of predated crypto, which are all these different accounting vehicles that were used in Enron to create the illusion of assets. There weren't assets there, but Chatelin and others who were in charge of Enron, you know, got market value way up, but it's an illusionist type thing. It was not there, but there were assets. And so I think the notion that the U.S. bankruptcy court process for the U.S. trustee appointing an examiner who could track the assets a little bit like, you know, maybe almost a quasi-law enforcement person in Enron. I worked in the Enron case with the examiner, and we worked with law enforcement community and others, just trying to find out where the assets were so we could recover them for the individuals who had lost their money, and a wide range of people. So money was recovered. In this situation, I think money could be recovered through that process. It's not happening in FTX in New York because the trustee of the U.S. Trust, the court, the bankruptcy judge, decided not to appoint an examiner and defer it to John Ray to be the sort of the sheriff on the block. I think it's working out well. It's a different type model, but I do think it's something that has maybe unique to U.S. law. I'm not sure how it applies international, but there may be some international application. But I just wanted to mention that it's sort of something that I see here that in this hypothetical, you have Binance, you have Celsius, and all the others that have gone into bankruptcy in the U.S. So that's something. I think there's a lot of international coordination that could take place with UK counsel and other counsel about tracing the assets.
Well, so now everyone in this hypo, for the moment, has received strong advice. The investigation has been done. The elements have been identified. The message is highlighted. Bill, I think we've done this in a record time. FTX, from my perspective, was a record time investigation, but here in 1 hour, I think, you know, we've outgone FTX. It's clearly worth noticing. At the beginning, I did say, everyone's wants to be on this case. So if, you know, any of you really want to be on the matter, it's now the time to stand up and to say any comments that you would want to bring. But I feel I did make the phone call to the 4 experts because, you know, it's kind of slowing down. We'll let everyone take a 30-minute break, I think.
I did want to extend things, if I could say extra time in soccer, that I do think that we should just, before we default to a nice break, a much needed break, probably from a hypothetical, I just think there are a lot of charges that will be out of the block pretty quickly out of the Southern District of New York, and we want to go into any of that, or is that more something for the next panel? Victoire, what's your thought on that?
I think the next panel has to.
So,
Joe, if I could ask you a question though. You talked about sort of setting the public stage. All these people are very public.
Right.
They all have private publicists. You got to figure the Twitter sphere, the X sphere is lit up on this, and Kroll's kind of tracing that and doing public sentiment. Nick, you know, when you're trying to advise clients, an individual or Joe, in your case, the board, there's going to be a ton of, I mean, we had people from the FT and GIR here yesterday. You're going to have People Magazine that's going to want to talk to your clients, right? I mean, it's going to be a media frenzy. How are you trying to deal with that as a lawyer for an individual or for a group of people?
Let's do the panel.
Yeah, that's it.
I have had cases where we've engaged, PR teams that we've worked with quite closely when there's been media attention or potential media attention on the case, and that is always a very interesting part of the case. We are often balancing clients' inclination to make public statements and put their story out there for people against, potential damage that they could do to their case or to their image if that backfires. And we will get advice from specialist PR teams that deal with legal matters that can help kind of thread the needle with these waters. But I think it's very important to engage PR experts when you're dealing with this kind of situation, and then get your clients to actually listen to the advice that they're given.
Yeah, I mean, I have a client who's in the media a lot. I mean, every client has a story to tell, so the question is, when are they going to tell it, who are they going to tell it to, and how much of it are they going to reveal? And, my advice if I'm representing individuals is almost never to the media, in the answer to any of those. But of course, some clients, they have different audiences in mind. So you're thinking about law enforcement, they're thinking about their reputation, or their constituents, or whoever. So, you just need to make sure you're always advising them of the risk. So you either get PR experts involved, or if they're not involved, you just need to try and think from their perspective, who are they trying to speak to and who are they most worried about? They may not be as worried as you are about law enforcement, and you have to acknowledge that and guide them, because they could make a big mistake if they prioritize the wrong audience and say the wrong thing at the wrong time.
And there's a U.S. analog to a person by the name of Boris Johnson, who's running for president, and every day he's saying something that's of use to prosecutions in the 4 cases he's being prosecuted in, and not to mention the civil litigation. So he's an impossible client, not your client. But if you were to have that gentleman as your client, you're trying to instruct him. I think in this case you have people that their whole life is in the public domain, and everything they do is on social media, and so I'm a bit of a Luddite, so I don't do anything. My social media is LinkedIn, that's about it. You won't see me on Facebook, but you can go there if you want to. Some people are just absolutely addicted to social media. They want people to know I didn't do anything wrong, and they begin to say things, and your point's just absolutely splendid, because it's the world we live in today. If you think you've somehow captured your client and got his or her attention, you probably have not.
And I think one point to keep in mind in such an international and cross-border issue is that if one is saying one thing in one country, it may have another impact in another jurisdiction, and that's very important to keep in mind with the PR team, so that they do grasp the international impact, and the fact that comments in one country may have significant consequences elsewhere.
And I think similarly, we see quite a lot with short-selling attacks, where the target is very keen to at the outset say this is nothing to do with us, this isn't true, as opposed to gathering the facts first and sort of making a very binary statement to begin with, while they assess before having to retract something and raise the
Thank you, everyone, and it's now time for a trial.